Mr. Clark's convictions due to insufficiency of evidence. That's laid out in Issue 1. And we ask this court to vacate his sentences with respect to lifetime post-release, it should be parole, and vacate the electronic monitoring. That is my argument.
And you've restricted the sufficiency argument to the specific intent?
Correct.
Yeah.
To the specific intent.
And the defendant did admit that the touching was inappropriate?
Yes, but that only goes to lewdness, not to the inappropriate. You cannot assume that inappropriate means for one's sexual desires.
You did not intend to make any further oral argument on the sufficiency issue. You stand on your brief.
Yes, unless this court has questions, I can flesh that argument. There's several points made already that Mr. Clark never touched them underneath their clothing. He never made sexual suggestions. He never had them remove their clothing. He never removed his clothing. He never exposed his genitals. He never touched their genitals. This was all a mere touching while they were sitting down next to each other. Was that for his sexual desires? He told the detective it was for not. He denied that. We don't have evidence of the sexual desires for the two girls. They just told him to stop. So you don't have evidence of sexual desires for them. And the state did not present what we argue sufficient evidence to show that specific intent that the touching was done for the sexual arousal for Mr. Clark.
Do we have any questions of counsel? I see none. Thank you.
Thank you.
May it please the court, the state appears by Assistant District Attorney Jody Litvin. I would submit the last two issues on the brief and quickly just hit the sufficiency of the evidence argument. First, just to point out, this court looks at all of the evidence in the light most favorable to the state. Intent doesn't need to be proven directly. It can be proven by circumstantial evidence. And the state argues we have sufficient evidence in this case of the specific intent of the touching was done with the intent to arouse his sexual desires. The evidence that was presented, there were two victims here. They presented testimony that Clark had rubbed their breasts over 20 times in the time when he had moved back to Topeka from his previous residence, and I think it was California. Repetitive touching almost every time that the victims were around the defendant here. He admitted this to the detective as well. He said that the touching was inappropriate, and he stated that he knew it was wrong, and then when he would try to move his hand when he realized that he was doing it, which I think goes against his later testimony that it was unintentional or unconscious touching, or not testimony, excuse me, when he was talking to the detective about how it was unconscious touching or he didn't know he was doing it. He also specifically told the victim's father when he confronted him about these issues, he didn't deny it. He said that the touching happened and he knew it was inappropriate and wrong. There was additional evidence presented by some of his journal entries, which said that he knew, which showed that an indication that he knew that the touchings were wrong. He said he was on borrowed time, just consciousness of guilt, and again, circumstantial evidence that he had specific intent in this case, that his touchings were done for his sexual desires. He also made reference that he knew that he would be going to jail. He could probably be going to jail for something like this. He made that comment to the detective, I believe, and as well to the victim's father. So there was additional circumstantial evidence there. Other than that, I think that pretty much outlines the evidence that was presented, and the brief discusses any additional evidence.
Do you have any further presentation for us?
I do not.
Okay. Any questions of counsel?
Just real briefly, was on the sentencing, was there, I'm just curious, was there a motion to depart from the Jessica's Law, do you know, at the sentencing? It doesn't matter
I
for you.
don't-
I'm more curious.
I can't remember.
Okay, that's all right.
Any more questions? Thank you, Counsel.
Thank you.
Reserve 2 minutes for rebuttal.
I request to waive rebuttal.
Didn't you say when you first stood up that there had been a motion to depart?
Yes,
Okay, there was a motion to depart that was
yes,
denied.
that's what I thought
There
had-
was a motion to depart. It was denied.
Correct.
Okay.
That's what I,
Okay,
Thought you
thank you.
said that.
Thank you. Okay.
Okay, thank you.
Any questions? Thank you.
thanks.
Thank you both for your arguments. We like those short arguments. Court will take this matter under advisement. We turn to the